Ready when you are. Would you like to reserve up to 5 minutes for rebuttal time?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Very well. You may begin when you're ready.
May it please the court. My name is John Cavalieri and I represent Plantation Homeowners Inc., petitioner in this case. The summary final order below should be quashed because it was entered despite several unresolved factual issues.
Mr. Cavalier, before you go into your substantive argument, can you address the jurisdictional issue that we have?
Yes, Your Honor. So the notice of supplemental authority was filed citing a 5th DCA order dismissing a similar case for lack of jurisdiction. So that case is a citation order. It's not published and is not even available on Westlaw. So I'm not sure how much authority that is. And in that case, they cite 2 Florida Supreme Court decisions in the criminal law context where the state is seeking certiorari. Now, the state is under an entirely different framework for review.
But we have a specific rule here, right? It's 61B-80.121.
Of the Florida Administrative Code.
Correct.
That's correct, Your Honor.
And that provides that the final order of arbitration, binding arbitration, may not be appealed.
That's correct. So that's why we are proceeding under certiorari. And certiorari is available where there is no statutory right to appeal. Under the GW development case, the Heggs case, and the Decker case. And as such, we're proceeding under Florida Rule of Appellate Procedure 9.190B3, which is where review of quasi-judicial decisions of any administrative body, agency, board, or commission not subject to the Administrative Procedure Act shall be commenced by filing a petition for certiorari in accordance with 9.1.
Of course, other courts have taken a different position, right? North Shore versus Baker basically took the position if there's no statutory right of appeal, then cert cannot be used to support the right.
Right, and again, that's in the context of the state seeking certiorari review in a criminal case. The state is limited by statute on what it can and cannot appeal in a criminal case. Here, we have a right to access the court.
Well, that's State versus Pettis, which was a criminal case. North Shore versus Baker is not a criminal case.
Correct, and that's the case that they relied upon.
Yeah, but I mean that's the 5th DCA, and they're pretty smart folks. Every once in a while they get it right. We have a tendency to pay attention to what they do.
I understand that, Your Honor. If we look at State versus Pettis and we look at the full quote that they cite, they're talking about the state. They're worried about the state circumventing the rules against not appealing adverse judgments in a criminal case. And also the state does not have an access to courts problem because they're already in court when they're seeking certiorari from the lower court. We are not even in court yet, which is why we filed for certiorari. Now, our alternative basis is that there is a statutory right to appeal under 120.68 because.
But what are we to make of the rule then? They're just kidding? That's our first offer?
So, Your Honor, I think that goes beyond their delegated authority. There's no statutory basis for them to make that rule. So under express separation of powers under the Florida Constitution, that goes beyond their delegated authority. To the extent they're relying on section 718.12554, they've misread that statute because 718.12554 applies to non-binding arbitration cases. Here, this is a binding arbitration case. So the statutes at play here are 720.306 and 720.311, and both of those say an election challenger must file a petition for mandatory binding arbitration with the division pursuant to section 718.1255 and the rules of the division. There's nothing in there that says the division can determine the appealability of its own orders. The only place.
Well, what about our rule 9.030B3? Rule of Appellate Procedure. This does not meet those jurisdictional requirements set forth in the rule.
So for the, in terms of certiorari, I think it does, Your Honor. Let me get through I don't have a copy of the rule in front of me, but I do believe this does meet the requirements for cert. We are seeking certiorari review of a quasi-judicial action in 9.190. But again, to the extent that the state DBPR is relying on 718.1255, it says there, nothing in this provision shall be construed to foreclose parties from proceeding in a trial de novo unless the parties have
Yeah,
agreed.
that's, I mean, to me, that's, I mean, either you have no jurisdiction or your remedy is a trial de novo in the circuit court.
Well, Your Honor, that's the problem. In a mandatory non-binding arbitration case, that's the case. That is correct, but this is binding arbitration. So trial de novo is not available in a binding arbitration case. But if you disagree with me, Your Honor, I would respectfully submit that we ask to be transferred to the circuit court for a trial de novo under 9.040. But
Sir, we're just having a conversation at this point. I've taken no position on anything. Your job here is to enlighten us.
I understand, Your Honor. Thank you very much. I believe, so if we look at 718.12554, there's nothing in there that says what you can do with a mandatory binding arbitration decision of the DBPR. It's talking about non-binding arbitration. And there's no rulemaking authority in there that allows them to determine what is appealable. Essentially, they're taking the position that what we say goes and you can't appeal us. And our position is there's no statutory basis for that, and that violates our right to access the courts, and it goes beyond their delegated authority. And so our alternative basis is statutory right to appeal under 120.68. And that's because the floor is set that a party may review. So a party who is adversely affected by final agency action is entitled to judicial review. Now, there's nothing in section 718.12554 that says a mandatory binding arbitration is not final agency action. Again, subsection 4 is talking about non-binding arbitration. So also, if you look at the other two statutes, 720.306 9C and 720.311, there's nothing in there that says the decision of the arbitrator in a mandatory binding arbitration filed pursuant to these sections is not appealable and is final. Again, the only place where it expressly says that is in the department's own rules. Turning to the merits, this election was not even close. The respondent lost by over 100 votes. And then when we look at what a petitioner must show in an election dispute, we must establish two things. And the first is, was there an irregularity in the process? The second is whether that irregularity reflected the will of the voters or resulted in doubt as to whether that irregularity resulted in the will of the voters. And a hyper-technical interpretation and strict compliance is not required under the case law, which is the Boardman case and the Beckstrom case in particular.
In this case, there was no quorum.
Sorry.
They used absentee ballots. There's no provision for them. Those two things standing alone, you basically had an election that you needed a quorum for, you didn't have one. A bulk of the ballots were absentee ballots. There's no provision for them. And those are two pretty serious things. This isn't like, we just messed up a little bit. I mean, no quorum, and the bulk, I think 70% or something were absentee ballots, of which there's no provision. That's pretty serious.
So, Your Honor, even if it is true that, even if the arbitrator was correct that the association could not use absentee ballots here, again, there's no provision in the bylaws that says you must be present to cast a vote at an election. And so,
but there's no provision that says you don't have to be.
Right, but if you look at 720.306.8b, it says if the governing documents permit voting by members not in attendance at a meeting, the bylaws are silent. And so the fact that
silence is not permission.
I'm sorry?
Silence is not permission.
Well, that's what the arbitrator said, and I disagree with that. There are instances.
Well, hang on.
That's a little different than the argument. The argument in a brief, as I understood it, is that this had been a historical practice, and that
And
makes
that's
it
correct.
okay. And I'm hearing something different now.
So that's another
Wait,
aspect.
this is the way we've always done it. That's always.
Yeah,
my
I mean, I
favorite
don't-
thing. You know, when
that-
I'm dealing
that
with
does not-
people in anything, they always say, this is the way we've always done it.
So yes, Your Honor. So I understand that this is exactly how they've done it for years. But
But
it
people
was a
buy homes
reasonable
and people buy
interpretation.
homes hoping that people are going to abide by the documents that establish the association.
Right, but again, there's nothing in here that prohibits this practice. The statute came into play in 2010. And so since 2010, the association has been using this because there's nothing in those documents to say you must be present and voting in order for your vote to be counted. I mean, why submit an absentee ballot and then show up at the meeting to make sure your vote counts? That's what the quorum protects. But even if it's true that you cannot use that, under the Beckstrom case, they say the court standard is even substantial non-compliance is not enough to toss an entire election. There needs to be a factual finding that even the non-compliance, let me get the quote, resulted in doubt as to whether the election was full, fair, and free. Not hyper-technical reading of the bylaws in light of the statute, and not hyper-technical, oh, no
Yeah, I
quorum.
can understand your argument if you had hyper-technical, small matters, things that didn't matter. But this is a quorum, and 70% of the ballots were in a manner not prescribed.
But there's no
I
obligation.
mean, that you had no authority to have an election at all. And then when you had it, the bulk of the way people voted isn't allowed.
Well, Your Honor, there was no objection before the election occurred. And these are all things that we're allowed to present at an evidentiary hearing. It says even by, so if you look at the Beckstrom case,
Well, there wasn't an evidentiary hearing, was there?
there was not, and that's why.
And did you ask for one?
We did in our response to motion. So we had to submit brief, each side submitted 2 briefs. In our response to their brief, we said, even if there is an irregularity here, we asked for a full evidentiary hearing, and that's on page, oh, that's in our brief below, that's in the record, at page, I'll supply that to you by letter, but it is in the record. I think it's 267. I think it's around 267-ish, but it's in our second brief, towards the end of our second brief below.
Isn't your real remedy just to have another election?
So it's our position that it's not necessary to have an election because
You'd rather go up on appeal and wait for a long time for a decision? I mean, this is beyond the scope of why we're here, but I have to say it. I mean, that when I read this, I kept saying, why don't they just have another election? And you don't have to answer it. Let's move on.
well, the idea, the board feels that nothing was wrong in the way they did things. There was no fraud. People actually voted. A member casting an absentee ballot is a member voting. You know, we need to look at all of the evidence and see, do the signatures match? Are people not voting who are ineligible? That didn't happen. All we're talking about here are 2 technicalities. And under Beckstrom,
Do you give, when you represent the HOA, do you give this much slack to somebody who's violating provisions of the deed restrictions?
well, Your Honor, there are
It
cases.
seems that you want some laxity on one side, and I suspect the homeowners association is not as lax when they're trying to enforce restrictions against homeowners.
Yeah, I understand that, Your Honor, but the standard is substantial compliance and whether it's full, fair, and free. And in an enforcement case where somebody didn't cut their grass, that's totally different. It's also a big deal to get 1,800 homes to participate in an election. It takes a lot of effort for these guys to get the ballots printed and out and get the word out that we're having an election. It's a big process and a lot of people are
Democracy can
involved.
definitely be annoying.
I'm sorry, I missed
I said democracy can definitely be annoying.
correct, but to do it all over again when they felt that there's nothing wrong with the way they did things, this wasn't even close. Because even unintentional wrongdoing So I think, so the reading that the bylaws allow this is completely reasonable. Even unintentional wrongdoing, as Beckstrom found occurred in that case, of statutory requirements was not enough. And they said the court is to void the election only if it finds substantial noncompliance resulted in doubt as to whether a certified election reflected the will of the voters. There was a trial, and the trial court said there are a lot of things that could have been open to fraud, but I find that there is no fraud. And that's exactly.
Let me interrupt you for a moment. You're up to 15 minutes, so you're into your rebuttal time, but it's your time. Use it as you wish.
Okay, thank you, Your Honor. Under the standard for cert, we need to go back because even if there is an irregularity, we need to know whether that irregularity resulted in doubt that the will of the voters, essentially, did the right people vote and did their vote matter? Okay, I'd like to reserve the rest of my time.
Very well, thank you. Ms. Martin.
Thank you, Your Honor. May it please the court. My name is Stephanie Martin, and I'm representing the respondent, in this case, Ryan Mudson. I appreciate the court highlighting the jurisdiction issue at the outset of petitioner's arguments. We did file the notice of supplemental authority after briefing had closed in this case to highlight the North Shore at Lake Hart Homeowners Association case. And that case, we do believe, is directly on point and controlling on the issue of jurisdiction. That case states that where there is no statutory right to appeal a final order, certiorari cannot be used to supply the right. In this case, the statutory authority for Rule 61B 80.1215 comes from Florida Statute Section 720.3069C. That statute states that any election dispute between a member and association must be submitted to mandatory binding arbitration with the division. Such proceedings must be conducted in the manner provided by Section 718.1255 and the procedural rules adopted by the division. The procedural rules being the key because of Rule 61B 80.1215 of the Florida Administrative Code, which provides that the final order of the arbitrator is binding on the parties and may not be appealed.
I have a situation where there is no check on agency action.
Your Honor, that is correct. That is the situation, but there's good reason for that.
But it says appeal. It doesn't say, it doesn't deal with our original writs jurisdiction.
I appreciate that comment. That's what the North Shore at Lake Hart Homeowners Association case dealt with. It was also a case that was also a mandatory binding arbitration election dispute in an HOA that was challenged. The arbitrator heard the mandatory binding arbitration proceedings on summary procedure, just like as is the case here, made a determination, and then the case, when it was appealed or when the association sought certiorari in order to be relieved of the arbitrator's orders, the court said that it didn't have, the 50CA said it didn't have the right to appeal, to use certiorari to supplant the appellate process. That basically there was no statutory right that allowed them to appeal, and certiorari is not a substitute for a typical appellate case, that it can't be used to supplant it.
Well, I agree it can't be used as a substitute, but it is original writ where a miscarriage of justice has happened. And again, I'm intrigued with the notion that we're left with no check on administrative agency action.
Sure, I would address that question in two parts. The first is that we're dealing with a very unique feature of homeowners associations. This is just related to an election dispute. If this were some other type of dispute, there would be additional opportunities for review. The reason there's not in this case is because association elections are very time-sensitive issues. Once a homeowners association holds an election, typically very short order, the directors are seated. If there is to be a challenge to the results of the election, it basically needs to happen immediately. Otherwise, the association and the owners are going to be in limbo, which is exactly what has occurred here, while the authority of the directors, whether they were voted correctly, whether they were voted in properly, is vetted by both the arbitrator and then potentially the appellate process. In this case alone, we're talking about an election that took place in August of 2019. And we filed and we proceeded expeditiously through the arbitration process. Now here we are sitting in May of 2021, and we still don't have a decision on whether what happened in 2019 was proper. Additionally, that has thwarted the 2020 election, which still hasn't been held by the association. Because of the time-sensitive nature of these cases, they really are the type that need to be heard quickly. And, as was pointed out previously, these elections are held annually. There will be the opportunity, if the agency decision isn't appreciated by the community, to vote in new directors. Ultimately, all of this doesn't change the fact that there are certain rules for an election that need to be held. In this case, all the arbitrator required is that the association follow its own rules, that it have a quorum, and that it not employ a procedure for voting, the absentee ballot procedure, that is not authorized by law, or that's not authorized by its governing documents. The quorum level, I'd point out, is low in this particular community. Typically, the default under Chapter 720.306 is that 30% is required to constitute a quorum. Here, we're already low because the governing documents permitted, as they're authorized to do, to 10%. This is significantly less than the statutory default. It should be at a bare minimum possible for the association to comply with that. In terms of the absentee balloting, the association amended its documents in 2019. If it wanted to authorize the absentee ballots procedure that's set forth in the statute, it clearly had the opportunity to do so at that point. To continue to hold elections in ways that historically it's done without a quorum or using an absentee ballot procedure that is not invoked by its governing documents it's just unacceptable under the circumstances. The election packet that was sent to the homeowners when they were voting specifically invited lack of quorum. It invited them to use absentee ballots that were not authorized by their governing documents. In this juncture, the association's behavior really was egregious in terms of conducting an election that was not authorized or conducted properly by its governing documents.
Remind me, if you would, did your client make any objection to the way the ballots were sent out to the homeowners?
Are you talking about prior to the election, or?
Yes.
So that is not a matter that's in the record.
Okay. Okay.
All right. The other thing I want to mention is that the legislative findings regarding the arbitration, the use of alternative dispute resolution issues in homeowners associations is set forth in statute 718.1255. And basically the comments are in subsections 3A is that owners are at a disadvantage when they have to litigate against associations for cost reasons. The association has the ability to depend on its assessments to pay its legal bills, while the owners that are challenging the associations have to depend on their own resources. The legislature said alternative dispute resolution, like the mandatory arbitration utilized here, is a more efficient and cost-effective way to address homeowner dispute issues, and ultimately results in efficiency, less burden on the courts, and a savings of costs for the parties involved. This is really important for election disputes as well, because if ultimately the homeowner can't raise a sufficient challenge because of cost restraints, time constraints, efficiency concerns, etc., they will not be able to advance these concerns in a manner that's effective or productive to ensure they're resolved. I would also mention that the North Shore case, in our brief, because this case wasn't determined until after we had completed the briefing deadlines, we have cited cases in the non-binding arbitration context in election disputes that are similar. And those are cases that were decided by the second DCA as well. That's the Jolly versus DBPR case, the Chicorella versus Sienna Villas at Beach Park, California case. These cases were decided under Rule 61B 043 subsection 7. And this rule is similar to the one at issue here, 61B-80.1215. It's very similar to the binding arbitration rule. The only exception is that, and I say it's similar because it doesn't permit going straight to appeal. The relief that's provided by that rule does allow for a trial de novo because you're talking about a non-binding arbitration, which is the main difference. But ultimately, those cases also were cases where the court determined that it wasn't appropriate to take jurisdiction of the appeal. The issues in this case regarding quorum and the use of absentee ballots are, I think, pretty important. Quorum is not, as petitioner characterizes it, a minor technicality. Proceeding without quorum is a substantial irregularity. Homeowners associations have been governed by quorum. They're not allowed to hold their annual meetings. They're not allowed to conduct business if there's not a quorum. So this is not, as the association would contend, a minor technicality. As to the issue of the absentee ballots, similarly, that's true here. It's not a minor technicality to allow 73% of the voters to vote in a way that's not authorized by the governing documents. These are substantial irregularities. Under the association's own cases they cite, these are the types of issues that require redress, and that was why the arbitrator addressed them in the way that he did. Your Honor.
So what about the absence of an evidentiary hearing? I mean, that's problematic on its face.
And I appreciate that. I would look to the rule on summary disputes. First of all, this is Rule 61B 80.114, and it's authorized by the statutory authorization is 720.3111. Basically, the rule provides that where there's no dispute of material fact, no evidentiary hearing is needed. In this case, there were never any disputes of material fact throughout the record. The association filed some additional affidavits and documents in conjunction with filing its answer and its motion to dismiss, and the case proceeded on with them. Those issues were never challenged by Mr. Munson, and the reason was the association admitted effectively that there was no quorum. They admitted that they used absentee ballots and that 73% of the votes that were cast were done through absentee ballot. Based on that and based on the rule, the summary disposition rule, there was no reason to hold an evidentiary hearing.
It's just a question of law, whether a quorum is required and whether absentee ballots are allowed.
Exactly. And I would also note in our brief, and I believe it was pages 26 and 27, we pointed to other cases where election disputes had been decided on summary disposition. It's not an uncommon way to handle these types of disputes. If ultimately the parties agree that this is what happened during the election, it's really just a matter for the arbitrator to determine whether or not it was proper.
Yeah, except for, this is the way it's always been done is never a good argument.
Well, and that's.
I didn't like it when your opponent made it. I don't like it when you made it either.
Well, I think ultimately the importance in this case of it's the way it's always been done is exactly why Mr. Munson brought this case. The election behavior, the flagrant disregard for the documents was of concern to him. And so that's why he sought the review. And we do believe that while the mandatory binding arbitration procedure without an appeal is unusual in most legal senses, it's also appropriate and justified by the circumstances and what occurs in election disputes. These are time-sensitive matters. They cannot continue to dwell without a resolution. It's burdensome on the association, on the community, and everyone involved.
Am I correct? for the factual matter would be whether or not the election was conducted in a fair and reasonable way. Is that how I understand the
So
process?
if there were to be an issue of fact, then yes.
That-
The authorities cited by, while many of them were not necessarily homeowner associate specific cases, but they talked about substantial compliance and making sure the will of the people were heard. Those are issues that in a factual inquiry would be important. Ultimately, in this case, there's no need for that. There's no quorum, and they used a method of voting that's not permitted by their docs.
Okay.
So at this point, there's no reason to undertake any sort of collection of evidence. Your Honors, if you don't have any more questions for me, I think I've covered the main points that I wanted to cover. I'm happy to answer any other questions that you have.
Thank you, Ms. Martin. Mr. Cleverleary, you have
Yes, Your Honor.
5 minutes.
Thank you, Your Honor. First of all, Mr. Munson, this is in the record, had won the 2016 election and did not object after winning that election. I want to also say that the summary final order rule, the summary disposition rule, was violated because in these election cases, you have to establish two things. One, irregularity. Two, did that irregularity call into question the will of the voters? And we did not have an evidentiary hearing on that. We need to look at, the arbitrator didn't even look at any of the ballots. He didn't look at the sign-in sheets. He didn't look at any of the minutes of the meeting, or sorry, he did look at the minutes of the meeting. He didn't look at,
But
he
what
didn't hear any
difference
testimony.
what
from
difference
the,
does that make if the parties agree there was no quorum and they used absentee ballots?
because first of all, the absentee ballot issue was disputed, that it was necessary, that they could not use them. They took a reasonable look at Article 6, Section 2 of the bylaws, which says nothing about restricting voters to being in person or by proxy. So therefore, 720.3068B can be employed, because it doesn't say anything, it allows, it permits people outside of an election meeting to vote. And so then quorum wouldn't matter, because if you have, we had over 300 and something counted ballots, 1,331 votes were cast for were accepted for 3 candidates. There was more than a quorum that voted. The quorum only is concerned about having 5 people show up and make decisions for all 1,800 homes. That issue is not really in play here because there were so many ballots. But now let's look at the ballots themselves. Were they submitted by tenants and people that were not allowed to vote? Or was this really the will of the voters? And that's what Beckstrom says we have to do. Even if there's substantial non-compliance, you still have to see if it reflected the will of the voters or not. And so summary disposition was inappropriate because we didn't do step 2. And we also didn't do the evidentiary hearing that we're entitled to under 61B-80.119. The other thing is the North Shore case was given to us by the arbitrator after briefing. So that's in the supplemental appendix. The arbitrator asked for a status update and said, oh, by the way, this case came out from the 50CA. What are your thoughts? So that case was not out there. And we think that, again, that case relies on 2 criminal law cases that are looking at certiorari in a totally different context and looking at appealability in a totally different context, because the state's right to appeal is very limited. There are no further questions. The order below should be quashed, and we should be going to an evidentiary hearing.
Thank you, sir. Thank you both. You can exit.